Welcome all of you for being here. Welcome to the National Spy Museum. I never said that in the beginning. My name is Vince Houghton. I'm the historian and curator here at the museum. This will be a really fascinating program talking about the 100th anniversary of the Espionage Act. A lot of times laws that are 100 years old don't really matter all that much anymore.
This is not one of
This
those.
is not one of those. And there are certain people who can certainly contest to that from their personal experience, but also every day in the news we hear this law being brought up again and again. And look, we're going to get to your questions about today, but you're going to have to kind of hunker through some conversation about how this law came around and how it's applied to get some of the background. And then you can ask all your Trump questions that I'm sure that you have in the back of your head. So let me let you know who's sitting here with me. To my immediate left is Mark Zaid, who is a managing partner of the law office of Mark Zaid, kind of on the nose, but that's okay. He specialized in litigation and lobbying on matters relating to international transactions, torts and crimes, national security, foreign sovereignty and diplomatic immunity, defamation, and the Freedom of Information and Privacy Acts. And just everything else. I mean, what else don't you do?
Don't do criminal defense.
Don't do criminal defense. So
That's
you can't.
why you never represented me.
Or
Right.
matrimonial.
Just about anyone you bring up you name drop somebody to Mark in D.C., he'll say, he was my client, except for all the people, criminal law, apparently. Through his practice, he often represents former and current federal employees, intelligence and military officers, whistleblowers, and others who have grievances or have been wronged by agencies of the United States government or foreign governments, as well as members of the media. He's been named as Washington, D.C. super lawyer every year since he was profiled in 2009, as well as a best lawyer by Washingtonian Magazine for his national security work in 2009, 2011, 2013, and 2015. Now, that's issued biannually, so it's not like he slacked off during all the even numbered years. And so we're looking forward to 2017. Hopefully, yes,
I have no idea.
Oh, I had no idea. So we'll all be in suspense. And as the National Law Journal once wrote, if Agent Mulder ever needed a lawyer, Zaid would be his man. He's also the executive director and founder of the James Madison Project, a Washington, D.C. based organization with the primary purpose of educating the public on issues relating to intelligence gathering and operations, security policies, national security, and government wrongdoing. He serves as an adjunct professor at Johns Hopkins University, teaching in the Global Studies National Security Certificate programs. He wanted me to add that he has defended people who have been charged in the Espionage Act. He has done multiple things, as far as even testifying in front of grand juries with the Espionage Act cases, so he knows a little bit about this law. Now, speaking of Johns Hopkins, to my far left is Mark Stout, who is the director of the master's degree program in global security studies, and also the director of the graduate certificate in intelligence, both at Johns Hopkins University's Krager School of Arts and Sciences, advanced academic programs here in Washington, D.C. He previously worked for 21 years in the national security community, including 13 years as an intelligence analyst for the State Department and the Central Intelligence Agency. He's also worked in the Army staff in the Pentagon and at the Institute for Defense Analyses. Dr. Stout is a senior editor at War on the Rocks, the co-author or co-editor of several books, and published articles in Intelligence and National Security Studies Intelligence, the Journal of Strategic Studies, and Studies in Conflict and Terrorism. Perhaps most importantly, he spent 3 years as the historian of the International Spy Museum. So he knows his way around a little bit.
I'm also Mark's boss at Johns Hopkins.
Right. And, my predecessor.
So watch yourself.
Yeah. I guess they replaced him with me. So we're going to have a lively conversation here tonight. We're actually going to start talking about the act itself. A lot of people don't quite understand why this act was created in the first place, and I think that's important because the United States went about 130 years from the creation of the Constitution to 1917, and the Espionage Act was passed, without really needing to codify a law about espionage in any kind of formal way. So what was it about 1917? Why did the espionage come about? Talk about the origins a little bit.
Yeah,
of this act.
so the actual legislation was introduced into Congress on the very day that Woodrow Wilson went to Congress and asked for a declaration of war, April 2nd, 1917. That same day, the legislation was introduced in Congress. But it had been sort of brewing for a while. The United States had gone through this period of, about 2.5 years, where World War I was going on in Europe, but we were neutral. But nonetheless, the United States in a lot of ways was sort of a battleground. There were German or agents of the German government who were engaged in sabotage campaigns blowing up munitions factories most famously, but bridges, placing incendiary bombs on merchant ships, this sort of thing, all in an effort to keep the United States from selling munitions to the British, the French, and the Russians. And in addition, there was what the U.S. government perceived as a very widespread propaganda campaign in the United States conducted by Germans and German agents. And of course, it's important to remember the context here also is that there was an enormous minority of German Americans at the time in the United States. German was the second most commonly spoken language. There were millions and millions of people, both American citizens and what we would today would I guess call green card holders, whose first language was German.
And Irish too.
And
yes,
yes,
forget the Irish.
and the
who
Irish
at the time
who had
really didn't like the English.
Didn't
all
like
that
the
much.
English. Yes. And since you mention it, the German diplomats, intelligence officers here, who were responsible for a lot of this sabotage activity, a lot of this propaganda activity, frequently recruited people who had a gripe either against the U.S. government, so sometimes African Americans, or more commonly against the British government, so a lot of Irish Americans and a lot of Indian Americans, East Indian Americans. But so the United States is just this battleground of clandestine activities, almost none of it actually spying as we understand right now, and that's sort of another important point here, is that 100 years ago, sort of everything that was done clandestinely, everything that was done secretly was sort of lumped into the word spy. And we'll probably get into this later, but I think that really affects how the Espionage Act itself was written, that it actually covers a whole slew of things that aren't actually spying in the sense that we think of it.
Let me jump in real quick because this will come in as no surprise to anybody, but the Espionage Act was used pretty heavy-handedly during the war. There was a lot of abuses of the original intent, if we want to call it that, of the law itself. Wartime brings out the worst, as we've been at 15, 16 years of war now, and so you see a lot of that today. But to give the audience a little bit of a taste of how this was overused during the wartime.
Yeah. So, the law basically said that nobody who isn't authorized to have national defense information can transmit it to anybody else, and nobody should receive it who isn't authorized to have it, and that furthermore, you can't make sort of false utterances that will interfere with the operations of the Army and the Navy. That was the first part, right? And so if you, for instance, spoke a lie or spoke something that the government would interpret as untrue information about how the war was going, that would be interpreted as interfering with the conduct of the war because you are depressing morale and making Americans and American mothers and whatnot less likely to support the war because, oh my gosh, we're losing, right? So simply mundane things like that.
So fake news was turned
yes.
into...
And more to the point, anything the government viewed as fake news.
Right, anything the government viewed as, yeah.
Right,
So.
they were the arbiters here.
Yeah.
Well, it went even further. I mean, much of the debate of the statute had to do with really First Amendment grounds.
Absolutely.
So understand, even though the First Amendment, we look at it as it's the First Amendment, it was actually the Third Amendment, but the other two never passed, so it became the First Amendment. There wasn't a robust development of it with the Supreme Court until years later. So at that time, there was all this discussion over how can we stop any type of anti-U.S. or allied fervor. So we had people like Eugene Debs, who was the socialist presidential candidate, was prosecuted under the Espionage Act for speaking out against the war. But my favorite was this movie producer who was sentenced to 10 years in prison because he did a film about the Revolutionary War. And that made Britain, our ally, look bad. And so he was actually prosecuted under it. And on appeal, they reduced the sentence to 3 years. So it was much more broadly interpreted and pursued at that time. And we had the Palmer raids going on with World War I. You look at how civil liberties went after the wars here. And when we did a podcast here about 15 years later, 2001 to 2016, where is the U.S.? I mean, there's a lot of things that we could still criticize, obviously, but if you really look at it, within a few years, the rubber band kind of snapped back from how extreme the U.S. started to go after 2001. The Supreme Court started to slap down the Bush administration in 2004, 2005. Well, World War I, it was just a completely different creature, and you need to understand the statute in the environment that it was created.
It's actually even more pointed with Eugene Debs. The specific thing that Debs was sent to jail for was, yes, opposing the war, but the specific manifestation of that was he gave a speech complaining about the infringement on the right of free speech. And for that, he was prosecuted and sent to jail. Mennonites, a number of Mennonites were sent to prison because they refused to serve military service because of their religious convictions. And that public example was viewed as interfering with the conduct of the military operations. And then in 1918, they actually passed a major amendment to the Espionage Act that made things even worse. This was called the Sedition Act, which got repealed in 1921. But the Sedition Act actually made it a federal crime to disparage or to insult the U.S. government, the president, the flag, the military uniform, to discourage people from buying war bonds, and a variety of other things that are escaping me right now. And again, this was all lumped under the rubric of espionage.
Sorry, when was the Sedition Act enacted originally?
1918.
1918.
Yeah. That would have been problematic today.
That would be extraordinarily problematic today.
I don't think
I'd be like
constitutionally survive.
I would be serving like 20 consecutive
Yeah,
life
probably
sentences.
most people in this room would have some problems. We've all said things about, the members of Congress or the president or whatever, sometime or another. We'd all be in jail.
So,
right?
so Mark, let me ask you this, because clearly the Espionage Act is not the same as it was during the First World War, and it's really the interwar period where a lot of this begins to change. Because if you skip ahead to 1929, when the American Black Chamber is shut down, which we'll talk about in a sec, basically this was our first use of signals intelligence during peacetime to kind of spy on other people. And then Herbert Yardley publishes the book called The American Black Chamber, which is about as leaker, whistleblower-y, whatever word you want to use, as it can get. He essentially spilled the beans on this program, and we didn't hang him up by his toes in town squares. How, in God's name, did we go from what you're talking about here, where people are getting imprisoned for, making movies about the American Revolution, to about 10 years or so later, where something like what Yardley does is not he's not spending the rest of his life
I
in
think
jail?
there's two things going on here. So even by the last days of the war, so even by late October 1918, the Attorney General himself is starting to get a little antsy about the degree to which we're just prosecuting everybody in sight for just looking wrong at the government or the army. And he actually issues an order at the end of October saying to all the U.S. attorneys, saying you can't start a prosecution against somebody for an Espionage Act violation without my personal approval. So even in the late days, I think we may be taking this too far. And then the war obviously sort of takes the fevered edge off of a lot of this when it ends in November of 1918. And then there's a couple years where it's still used for various things. But after 1920, nobody's prosecuted under the Espionage Act again until 1936. And in fact, 1921, President Harding pardons a couple dozen people who've been convicted of Espionage Act violations, including Eugene Debs. And then when Franklin Roosevelt comes into office, 33, he pardons the 1,500 people, both men and women, still left in prison over the Espionage Act. So part of this is sort of, and we may have gone too far, but there's another thing going on too, and that is that in the interwar period, both the intelligence agencies, which are primarily the Office of Naval Intelligence and then the War Department's Military Intelligence Division, and the FBI are shrinking, and they're sort of not really organized and focused to deal with espionage stuff. They sort of just don't have the expertise anymore. All of that left and is sort of in bad odor. So it's not until 1936 when actually in that year there's two separate cases of former Navy officers who are spying for the Japanese that this sort of springs back to life. And actually in the first one that came up, there was a lot of back and forth, like, do we really want to prosecute this? Justice Department said, well, this is egregious, and the State Department said, we're not sure it's so egregious, and by the way, this could cause a diplomatic crisis with Japan. And it actually went all the way to FDR, and FDR said, yeah, we got to do this, and that sort of revived it.
Which is interesting because during the 1920s, there was a massive Red Scare in the United States. They considered the one that comes under McCarthyism is considered the second Red Scare. And so the first one, we saw communist spies running around, and the fact that the Espionage Act was not used very heavy-handedly during that
past
time.
1920, it wasn't. But you raised the Yardley thing. Yardley's very interesting here because Yardley had basically, sort of slightly simplified story, he'd headed the American signals intelligence effort in the United States during World War I, and then after World War I, the War Department and the State Department kept his efforts going, breaking foreign diplomatic codes, they were jointly funding it. And in 1929, the Secretary of State, Stimson, who during World War II was a big consumer of SIGINT.
Yeah, he certainly liked SIGINT then.
Yeah, he loved it then. But in 1929, he found out about this. He's the new Secretary of State for the Hoover administration, and he's briefed on this, and he's appalled, and he shuts the whole thing down. Gentlemen don't read other gentlemen's mail. Well, Yardley's now out of a job. And so as Vince mentioned, he writes a tell-all book about how we were breaking codes, and here are some examples of the codes we broke and all sorts of stuff. And the which comes out in 1931 is a bestseller in the United States, translated and in Japan. It's translated into a whole slew of languages, including Japanese. And the government, interestingly enough, even though the Espionage Act is still on the books, doesn't prosecute him under it, and it's really not clear why. And there's a couple of possibilities here. One is that they may not have wanted to, sort of as a policy matter, interfere with the actions of the press. Right? He had a commercial publisher, somebody who's still in business, and I'm blanking on it. I don't know. A major publisher who's still in the business did this book, right? So they may not have wanted to interfere there. Another possibility, and here I'm about to sort of throw this to Mark, but the Espionage Act does not actually speak about the unauthorized transmission of classified information. Classified information, like quote-unquote espionage, was not a well-developed concept, didn't really exist actually as a concept in World War I. What it speaks about is the unauthorized transfer of defense information. And what Yardley gave away was actually peacetime decryptions of foreign diplomatic communications. And so they may have calculated, gosh, that doesn't fit the description of, quote, defense information. So for whatever the calculation was, they ended up passing a law in 1934 saying you can't release decrypts of foreign diplomatic communications.
But it's still, Mark, it still doesn't necessarily criminalize leaking classified information to the exact extent.
National defense information, I don't think there's certainly not been any modern cases where the information wasn't classified by the terms that we know it now today, which are more modern, that came about more from the Eisenhower administration on. So confidential, secret, top secret, you might hear TSSCI, sensitive compartmented information. Also from Yardley, we started to have pre-publication review requirements that you had to submit. If you signed an SCI agreement with any agency, you have to submit your writing to your agency, or technically the agency that last held your security clearance.
It's his fault.
For them to review, for them
Anyone
to
who's
review
been
it.
in PRB hell, it's
They got around to the Cold War.
Yeah.
to determine whether or not there's classified information. So the government can block in perpetuity anyone who had access to classified information from publishing the classified information. If it's unclassified, you have a First Amendment right, anyone does, other than yelling fire in a theater type thing, of publication. Now that's a breach of contract issue. That's not a criminal issue. So there's a famous case of Frank Snepp, who was a former CIA case officer in Vietnam, and Frank wrote a book called Decent Interval that came out in '79 about his days in Vietnam, and he opposed the end of the war. He didn't submit it for pre-pub review. They sued him civilly, and they seized all of his profits, all of his royalties. To this day, actually, they still get the check from Random House, who published the book. For those who are interested in, Yardley is a fascinating character. Went on to write books about poker that are still renowned today, about how to play it well. Died sort of destitute, but one of the board members, advisory board members, David Kahn, wrote a book, a biography on Yardley a few years ago. It's a great book. And he's buried in Arlington Cemetery. If you know where President Taft is buried, right off to the left is a section of actually quite a number of famous people, including secretaries of defenses. And I don't know how, but Yardley is in this really prominent section, which I find fascinating, given what he did and how ostracized he was.
Can I just briefly pick up on a point that you made here, that classified information isn't per se, with some minor exceptions like the stuff that came out of Yardley and things related to how to build nuclear weapons and that sort of stuff. Classified information is not per se defined in the law, right? So that comes out of, these days it comes out of executive orders. In the pre-World War II era, all the the definitions of what is confidential and what is secret and how those sorts of kinds of information are supposed to be handled came out of Army and Navy and State Department regulations, right? This is not a system that's built intrinsically on something that's in the criminal law domain, which is why it's become easy now, but why I shouldn't be talking about this is more your expertise, but prosecutors have to talk about, okay, so person X released top secret information. That's per se not a problem. You need to demonstrate that it's national defense information, which is these days easy, but is nonetheless a logical step that has to be made because it's not in the law.
So let me ask, you mentioned that when Yardley published his book, the publisher, there was some First Amendment issues because the publishing company was still really well known. Let me actually kick this question to you, Mark Zaid. Is there anything within the Espionage Act that applies to media about the people actually publishing this information? So can the New York Times or the Guardian get in trouble, just hypothetically, for publishing information, let's say, from a former NSA or Booz Allen employee who gives it to them? Hypothetical. Keep it in the hypotheticals.
I mean, the short answer is they could. The statute has no exception for the media whatsoever. And there is no such thing as a federal shield law. I mean, there are state shield laws for the media, but obviously states have nothing to do with classified information. That's a federal domain. There are the provisions that exist for the Espionage Act today, which are basically in Title 18, 793 through 798. They're virtually unchanged since 1950. That's the last time it was amended, actually, any of those provisions to add some internal security stuff. And some of the provisions talk about the publication, the unauthorized publication, or the unauthorized receipt of classified information, which frankly could apply in its literal terms to anyone here in this room. So, I mean, I represent, former agency case officers, a lot of journalists who have either accused of leaking or convicted of leaking or who are in receipt. One of my clients published classified information yesterday by his own very wording in his article. This document is classified. And theoretically that they could be prosecuted. I gave him some hell about it.
Probably
the writer could be prosecuted, but you're saying it's theoretically the publication.
The publication or the individual writer in receipt. So the only thing that has stopped, now I'm not going to say that's not a contentious argument, because there are certainly some people, lawyers, colleagues of mine, academics, who believe that there could be a constitutional challenge to it were any journalist prosecuted. What I say to a lot of my clients, especially those who come to me when they're writing a book, and they're like, well, I'm not going to submit it. And statistically speaking, there's only been 4 people that I know of who have ever been sued, all by CIA, DOD, for not submitting their book through pre-pub review. And I've handled like 20 lawsuits or something like that. And I tell everybody, do you want to be the one who they make the example of? Because I don't want to be.
Well, there's already been an example of No Easy Day.
Well, yeah, and I'm his expert witness in his lawsuit against his.
Remember when I told you that any name you bring up, Zaid knows him or represents him in one way or another?
So there are constitutional arguments, and you know what? And as far as I'm concerned, they're mostly academic, and I don't want to be the one who's trying to have to make those arguments. So The fact of the matter is, from a policy perspective, the U.S. government has decided it is not going to go after journalists. Now, at times it has pushed it a little bit. So we had a few years ago during the Obama administration, James Rosen at Fox News, who was associated with the Stephen Kim leak prosecution, who was a State Department official. James was noted in the FBI supporting affidavit as a potential accessory, which by definition of the statute he is, but they weren't going after him in any way. They also got subpoenas on the AP's, the Associated Press's phones that went really broadly, like encompassed 100 different reporters, because there was a main phone in the office, and I think, if I remember, they went after even some of the journalists' private phones. None of that's supposed to happen actually without telling the reporter first, to give the publication the opportunity to challenge it in court. But Eric Holder and President Obama's administration, and Eric Holder or the DAG, the Deputy Attorney General, would have had to sign off on it. That's the policy. So as a policy, though, and they took a ton of hell for that once that became known. So they added to the policy to say they're definitely not going to go after anyone in the press, but it's a policy. So that policy can change, just like that, if anyone wanted to. There's only been one journalistic entity. I only say 2 points on this. One journalistic entity that the government started to go after, that was the Chicago Tribune in 1942.
Post World War One.
1942.
Yeah,
post World War One.
Well, you said you only one, and I want to make
No, there
were a bunch during World War
Oh,
One.
I'm sorry. Yeah. You're right. Totally right.
Nerd fight.
Yes.
Nerd fight.
Post World War One.
Empty the room.
The Chicago Tribune wrote, and there was a great Washington Post story on this like a week ago or so. The Chicago Tribune, by luck, had a journalist on a Navy ship, and the journalist saw some scribbling on that had just been left out that gave him the indication that he could write a story that we had broken the Japanese codes dealing with Midway, and that we were able to know where the Japanese were going in advance. And they wrote this story, and you can imagine the War Department was incensed about it and actually convened a grand jury in Chicago to go after them. Didn't end up indicting and decided to pull back from it because, unlike today, in 1942, unless you were in Chicago, who the hell knew that the Chicago Tribune wrote this story? Nobody did.
It was not on the internet. Yeah.
And there was no indication that the Japanese knew about this story at all. So you can imagine if something now had happened, there's no way of having that. The only...
Can I just quickly
interject?
interject? There's going to be a book coming out on exactly that case from the Naval Institute Press this fall. I have no idea if it's any good or not, but if you're interested in pursuing it, go to Naval Institute Press. I don't work for them, but I'll take it.
Mark $1 for everybody's soul.
Then, fast forward to 1971 in the Pentagon Papers case. So, understand what Daniel Ellsberg did in releasing the information and the lawsuit that resulted against the New York Times and the Washington Post, and there were other newspapers actually involved, but nobody ever pays attention to them, like the St. Louis Post-Dispatch was publishing them and stuff, but nobody ever pays attention. So the government decided to go after them civilly and try and get an injunction to stop them from publishing. So the Supreme Court ruled in a 6-3 decision, I think it was, that there's an incredibly high standard for the government to get an injunction civilly against publication of classified information. But 4 of the 9 justices either directly gave a thumbs up or insinuated that if the government had gone after the New York Times criminally, they might have ruled incredibly differently. So that's still out there as a possibility.
Can I ask a question as a layman? I mean, there are other forms of speech that are not protected by the First Amendment. So obscenity, child pornography, and fighting words, I think, right? Do you think it's plausible that if a policy decision were being made, we're going to go after publication, even after the New York Times or whoever, that it might actually survive Supreme Court scrutiny? Given that there are these other they apparently came close, and they didn't ask the right question, but there were some indications in 71, they might have been in the ballpark, and there are these other exceptions. As I say, I'm a layman here legally, but it's
doesn't it
I've been
depend on the
curious
court?
about.
I mean, if you have
that's probably
it very much depends on the court. And in the academic articles that have been written about this in the last few years and deciding could a journalist survive prosecution, have talked about a few different Supreme Court cases. One's called Pickering, which is from the late 60s. It deals with public speech. When can a government employee, it was a state employee in that case, when can a government employee essentially reveal information and we'll talk about this with the public interest defense, whether there should be one, whether or not what they're saying is in the public interest, and that outweighs them being fired, which is what this case against this school district was. But that's been a little bit harmed in the last few years. There was a case called Garcetti a few years ago out of Los Angeles, again out of a state context, of a prosecutor who released information that was criticizing, I forget the specifics, criticizing something that was going on in his office, and it was deemed that what he was doing he learned as a result of his work, his employment. This was his job, and you could not reveal information that related to your job and have protection. And there's been a little bit even that's pulled back from that. The problem, if you talk to anyone who considers themselves a constitutional scholar, and I consider that I litigate constitutional cases, but I am by no means a scholar, because I don't understand how they understand anything about the Supreme Court. Because the case law changes literally from case to case, and they don't have to explain and differentiate their cases. So when I deal with some intel, national security litigation, I'll give you a perfect example. In 1988, there's this case called Department of Navy versus Egan, which anytime if I want to challenge a security clearance decision or anything really relating to national security, I can't, because the Supreme Court said that essentially they don't have the ability, they don't have the education, the intellect to understand national security. That's not their job, it's the executive branch's job. And so they defer any type of authority to the executive branch. So they refuse to take jurisdiction since 1988. That same term, within a 6-month span, with the same 9 justices, they ruled in Webster v. Doe, which was a CIA, I think he was a case officer, but a CIA employee who was homosexual and was being fired at the time, who sued for discrimination, and the agency tried to get the case dismissed, and the court said, nah, national security, classified information, the district judge can deal with it. They can just deal with it in discovery, and they can rule on how best to protect national security information. So the same court in a 6-month period came to this diametrically opposed decision. So I don't know how it would happen today. Now, it's very relevant today because the discussion that's going on apparently in the Trump administration is, do we prosecute Julian Assange, or is there a secret indictment against Julian Assange?
Let me take a
and
step
is he
back,
a journalist?
Because we'll get to Assange, but we skipped over the Obama administration, which I think is incredibly important to have a conversation about, because that was, it's probably why you've got nice clothes on right now. The fact that there were more Espionage Act related cases.
Joseph A. Banks.
Yeah, all right. There are more
3 suits for $900.
During that 8-year time period, there were more Espionage Act cases, particularly about leakers and whistleblowers, about leaking and whistleblowing, than in the entire history of the act itself.
Well, let's differentiate. The cases of actual espionage of people selling secrets to foreign powers sort of continues along. It's that it's the leaking to the press or to whoever. This is really the issue.
Wait, so the Obama administration used the Espionage Act in very different ways than people have prior to that, and to some would argue excess. Others would argue that it was used correctly, but you can't ignore the fact that I guess the real number is that if you take every administration going back to the beginning of the formation of the Espionage Act before Obama and added up all the times they've prosecuted leakers / whistleblowers, the Obama administration by itself is more than all of them combined.
Yeah, I think there were only 3 before that, weren't there?
Something like it was.
Yeah, so there was Ellsberg, who ultimately got off. There was Samuel Eliot Morrison, the guy who released satellite photos of a Soviet aircraft carrier under construction to Jane's Defense Weekly.
Sold them.
So, yes, because and I think he said also, correct me if I'm wrong here, I believe he said he wanted the U.S. public to be aware of the Soviet naval threat. And then there was another one, I think in 2006, and then there were 19 or something in the Obama administration.
Well, so some of the cases that the Obama administration handled were started during the Bush administration. So, like Jeff Sterling, who was my client, who was prosecuted and convicted and is now still in jail, unfortunately, that case started during the Bush administration.
You weren't his criminal defense.
I wasn't. No, I got actually. That was when I got pulled before the grand jury, and so I got bumped off the case as a conflict because I was a fact witness. That was interesting. Most of the grand jurors were falling asleep while I was talking.
Are you allowed to tell us that?
Yes. The grand jury witnesses are allowed to say whatever we want as far as what we saw. The grand jurors are not allowed to, or the prosecutors. So I started representing people who were accused or suspected of classified leaks back in the mid-'90s. And especially back in the mid-'90s when the Washington Times was actually does it even exist anymore? It's online, right? And I don't think is there an actual paper anymore?
Yes.
I don't know. Yes? So, it was awesome back in the 90s. 25 cents was the Washington Times and the Washington Post. And it was great to read the 2 different papers and get a different sense. So Bill Gertz worked for the Washington Times back then. And, oh my God, the government wanted to nail his ass in the spy museum lecture? Wanted to nail him so badly for publishing classified information and all of his sources, of which he apparently had many. They never could, and I remember they investigated one of my clients for being one of Gertz's sources. They never could because they could never prove it. And my view, at least, is the reason why we've seen more leak prosecutions. It's a double-edged sword. It's technology, and it has increased the ability to be able to grab a lot of classified information, as Manning and Snowden showed. Hundreds of thousands, if not more, classified documents onto a thumb drive, onto a CD-ROM, and that becomes a physical security question as to why they should have had the ability to do that, or Reality Winner, which was not a large, all we know is so far one, but the ability to reach into, in her case, allegedly, of course, reach into a database that she had authorized access to, but was grabbing documents she had no need to access. So why was that? Why was that being allowed? But the double-edged sword of it is so much easier now for the U.S. government to track the accessing of classified information, or whether, and we could discuss and debate whether the information is really classified or not, but information that the government says is classified, and frankly, unfortunately, that's where it stops, because the courts have not allowed, and I totally disagree with this, have not allowed for legal challenges to say that's not classified or it's overclassified. Yet I can do that in a FOIA case, in a Freedom of Information Act case. I can challenge the classification, and I can get a judge who has statutory authority to say, no, it's not classified, but not in an Espionage Act case.
So you could have somebody who's prosecuted because of a particular classified document that 10 minutes later you FOIA and it becomes declassified, but because they leaked it when it was classified,
theoretically,
they're still liable.
I mean, at least statutorily, I mean, there may obviously be policy discretion, prosecutorial discretion issues, but I mean, if you look at Reality Winner's case, just going by what the FBI affidavit says, so when the Intercept published this classified document, and supposedly that's the document in question, NSA was, the Intercept went to the government and said, we've got this document, this is what reputable journalists do, we've got this document, you can try and persuade us not to publish it, if you can persuade us, and many publications have not published, or have changed certain things, redacted certain things, as the Intercept did, actually. Well, it didn't take too long, and I know there's been some issues about did the Intercept burn their source. I actually think they've been treated a little bit harshly. Actually, one of those journalists was a client of mine, not relating to this. But they said, well, there was a fold in the document. In the photocopy, they could see the document had been folded, so they knew it had been printed out. I don't really know if that really did much, because once they were able to trace where the document was from, the NSA went to their system and could track who accessed the document, and then who printed the document. And there were 6 people in the country, or the world, I suppose, who printed the document, and then they went to, they talked to all of them, and they accessed, I suppose, all of their computers, but they accessed Reality Winner's computer because she had accessed her personal email account on her work computer. So if you work for the government, you might want to think twice about doing that. Frankly, some of the intel agencies have keystroke tracking, so you put in your password to Yahoo and you just gave them your password.
Pretty sure they probably had it already, but I don't know.
And she was the only one of the 6 who had been in email contact with the Intercept. So look, no brainer there. And the same thing with all of the other cases. It has been technology that has enabled the government. So I don't think, frankly, it's that the go back, say, Nixon, thereon, it wasn't that they didn't want to prosecute people, it's that they didn't have the evidence to prosecute people. And then
I think Nixon would have loved to.
I'm sure. Yeah.
He would have been all about that.
And then you can go into all sorts of issues about whether these cases should have been prosecuted to the extent they were, what the sentences, whether they were too harsh.
Let's talk about Assange then, because that obviously we can't get our hands on him. I mean, the if he's smart, he just lives the rest of his life in the Ecuadorian embassy because, but he is not somebody who is under U.S. law because he didn't do anything when he was. Well, maybe he did do stuff when he was.
But there's nothing with respect to nationality in the statute, so he's subject to U.S. law.
Everybody. He may have solicited this information, which would be a violation of U.S.
And I tell you, if and when a journalist, a journalist where everybody in this room would say, I agree that person is a journalist, because we could debate Assange. if and when someone who's a journalist is prosecuted, I think it's going to be that there's actual evidence that they solicited somebody to specifically go get classified information. I mean, I get calls from journalists all the time who are national security journalists who are asking me about my covert clients, the cases I have that involve classified information, and I have never had a journalist directly ask me, could you give me information that's classified? They dance around it. They know not to ask me. One, I'm not going to give it to them, but two, they know not to do that. They'll say, look, hey, Mark, anything you want to tell me, I'm more than willing to listen to. That's
never been tested before, that
no.
level. So if Assange, it turns out that he went to Chelsea Manning.
Well, then they don't have to worry about as much about being a journalist. That's why I say that would be.
So soliciting the information
pattern
would solve the problem of him being arguably.
I mean, clearly they would raise it as an argument, but I think it would detract a lot from any type of sympathy, and from a policy perspective, if that were the case. So then the question comes into, obviously, is he a journalist? He made a speech a few weeks ago, I think when Sweden dropped the charges or the investigation against him. He went out on the balcony in the Ecuadorian embassy. He gave a speech how the U.S. government is infringing on his First Amendment rights. Okay, you're very speaking. First of all, you're not in the United States anyway. But in any event, I think your very talking is showing you have First Amendment rights, and everybody in the U.S. reported on it. But that's a separate issue right there.
Got sent to jail for making that complaint.
Yeah, right. 100 years earlier.
What if intelligence agencies can tie WikiLeaks directly to the Russian government? That there's argument that when WikiLeaks was created, when Manning leaked to WikiLeaks, it was still somewhat above board. But there are those that have seen it perhaps slowly moving over to doing the bidding of the Russian government.
Well, so that brings it more. That could potentially bring it more from Section 793 into 794, which is your true espionage of giving information. It was a very interesting argument in Manning's court-martial. The one charge that failed, that I was the most concerned about, because it's a fascinating academic argument, at least. They charged him with aiding and abetting a foreign power. And the argument is that by publicizing the classified information, you've given it to our enemies. And if you think about it, it's not a bad factual argument. In some ways, you could argue that someone who leaks classified information, real classified information, and it's published by the New York Times, that could do more damage than if you only gave it to the Russians or the Chinese, because only the Russians and the Chinese had it and whoever they shared it with. If it's published in the New York Times or published in WikiLeaks when the actual document's published, every intelligence agency around the world has it. Now the judge...
And non-state actors.
Even non-state actors. Now the judge in that case denied that, found him not guilty of that charge because she realized, wow, that's a real slippery slope to go down. But it's an interesting thought with respect to that. So the Obama administration supposedly decided, from a policy perspective, they're not going to go after Assange. He's too close to being a journalist, or at least a publisher. And the reports are now that the Trump administration and Sessions Justice Department is rethinking that. I don't know if any of that's true. This is just what the press reports are about it. But it would raise some really interesting issues. And the press has already come out. The New York Times, I think, did an op-ed, or at least the Ombudsman, and I think maybe the Washington Post, about, don't go near Assange. We don't like him, obviously we don't condone what he's doing, but if you go after Assange, we see you going after journalists, and that's a real slippery slope. I think what any administration would argue is, it's only a slippery slope if we start sliding down it. We can go up to the edge of the line and decide this is what we're going to do. We're not going to go too any further than that. But obviously, you never know what the next person is going to do after that.
So let me ask you this, because we can debate WikiLeaks all we want to. We can actually debate leakers versus whistleblowers all we want to. We could probably have a multi-hour conversation with the people in this room about what counts as what. But let's talk about the whistleblower idea, because there hasn't seemed to have been a methodology for true and effective whistleblowing that doesn't get kind of sucked into this Espionage Act conversation. And I'm not being specific to a particular case. I think across the board, it seems like it's very difficult to go through the process, and then the final step of the process being no one's listening to you, whether it's Snowden or otherwise, and have that as a adequate defense for any kind of Espionage Act.
Do you want to start?
Nah, go ahead. You're the expert on this. I've got opinions, but you've got solid arguments.
So, for one thing, not every leaker is a whistleblower.
Right.
So I did an op-ed in the Washington Post, some of you might have seen last week or so, where I said, reality winner is not a whistleblower. Now there's two components to that, basic components. One, if you leak, the way the system is set up, you can't leak classified information or distribute it to an unauthorized person and be a whistleblower, just by statutory definition, regulatory definition. You could still think someone is a whistleblower, but they're not protected by law by going outside the system. So by definition, anyone who does that can't be a whistleblower. Then I don't think Reality Winner's a whistleblower anyway because of what she allegedly revealed. I don't think that document blew the whistle on anything, which is defined by revealing waste, fraud, abuse, gross mismanagement, or unlawful conduct. So policy disputes, which probably all of us could have with different agency decisions and administrations, policy disputes, that's not necessarily whistleblowing. It could cross a line into it, of course. So the way the system is designed, it is by no means the best. It could stand for a lot of improvement, especially in agencies cooperating, communicating, and sort of embracing whistleblowers, so that when they come forward and complain, as many of them try, to go through the system first, whether it's through their chain of command, an inspector general office, an individual member of Congress, an oversight committee, pre-publication review of their views, or FOIA litigation. All of these, or all of that at once. Many times, once they try that route, they hit a stone wall. Nobody tells them anything. And I keep telling this to the government. I don't understand it because I've seen it in clients of mine. I've watched as some of them have gone to be incredibly rational and sound about it, but after they were blown off so many times, they've become antagonistic. They've become insubordinate at times in their workplace.
Those stories
and then
come
they leak.
out, though. Those stories come out, and whether you believe this or not, and I bet the room would be split in half, that Edward Snowden, his true motives, as he says, were that I watched everybody else get blown off and prosecuted and try the whistleblower route, and it ruined their lives. So why even do that myself? And he went straight to the whole leaking part. Now again, let's not take him whether he's being truthful or not, but that argument has convinced a lot of people. And kind of that skipping the bad process and going straight to the leaker side.
Well, I think that gets to, I just want to sharpen what you said at the beginning, because I think your question gets to that, is that whistleblower really, in some sense, has two definitions. And I think a lot of the discussions and the arguments that Americans have about this, including with regard to Snowden specifically, is when one side is using one definition, a reasonable definition, and the other side is using another. There is a legal definition, a whistleblower, under which Snowden and a lot of these people, just Reality Winner, do not meet. Period. End of discussion. It's quite clear. But there's also the sort of general intuitive understanding, not based in the law, but based in our understanding of politics and morality and all that sort of stuff, about what a whistleblower is, that I think is different. And so you can have individuals who meet one definition and not the other.
It's like
I think a lot of our,
when Webster's dictionary redefines a word because of common usage, that's kind of which they've done.
But then, and this is my debate with a lot of Snowden supporters, I think you got to break certain things down with respect to Snowden in particular. He leaked information about the domestic surveillance program. Again, by law, not a whistleblower because he went outside the system, but certainly many people could consider him, and as a generic rule, I could say, okay, there's some real legitimate questions about the NSA's domestic surveillance program. You had one federal judge here in D.C. who said it was unconstitutional. 20-something others said it was, but you had a 3-judge panel in New York at the Second Circuit say that it was unlawful because it exceeded statutory mandate that Congress had given it. I think you can have a big debate about whether his disclosures really effectively changed anything, because the Congress kept the program in place for months and then really didn't change a hell of a lot, but that's a separate argument. But then you look at everything else. This is the danger of technology. Everything else he took supposedly, we don't really know, over 1.7 million documents. We don't really know. This is just what the government says. You can't, and Manning too took about 750,000 to 900,000. You can't read that. I mean, it's just impossible for anyone to have read it. So all of this information, other than some of the legitimate stuff that Manning was really concerned about, which was legit, and some of the stuff that Snowden was concerned about, that was legit, what about all the rest of the stuff? So you might not think it's a smart idea that the Obama administration gave the green light to listen in on Chancellor Merkel's cell phone conversations. You know what? Usually friends shouldn't spy on friends. That's a pretty good rationale, right?
Well, that's yet another discussion.
Yeah, Mark and I are like, well,
I'm not so sure I agree with
try
that.
not to do it. Although there's really...
No, just
there's
don't
really,
get caught doing it. It's
caught doing
really
it.
the issue.
There's some really good reasons why we need it, because Germany had some significant policy differences than we did, especially with Iraq and Afghanistan, Iraq at least. So there were some really legitimate reasons, and I could understand why people would think that that's not a good idea. But I'm sorry, there's nothing illegal about what we were doing there. In Germany, it's illegal, but under U.S. law, this is what all the countries do.
This is what intelligence agencies do.
This is what
They
NSA
break
was
foreign
created
laws
to do. Okay, and that's the risk we run. And who the hell is Snowden to release that information? Because if he even knew of it when he released it, and I don't know if he actually read that document or documents. But who is any individual, doesn't have to be Snowden, who is any individual to make that decision because they had a policy difference with that information?
So, but all Snowden did was to give that information to 2 people. He didn't release it. He didn't put it in the Guardian. He didn't put it in the New York Times or the Washington Post. He gave it to Glenn Greenwald and Lawyer Poitras.
And Bart Gellman.
Oh, and 3 people. But and they're the ones that decided to actually publish this classified information. So
I'm going to go give this loaded gun to the 3-year-old who lives next door, but I'm not responsible for what the 3-year-old does. Not that I'm saying the journalists are 3-year-olds, but that's the law doesn't follow that. I mean, that's,
and
people
there's
say
nothing
that.
in the Espionage Act about how many people you
But
have
the
to
law
give.
doesn't
You just
follow
have to
that.
communicate it to an entity not.
So I think the big question, and this is a leading question, but it's kind of a fun question to have, is it seems like this could be really tightened up. It's been 100 years.
Mm-hmm.
There have been bits in pieces that have been tweaked. There's been some changes over the years. But with the advent of the internet, with what you talked about with technology making it dramatically different about how espionage is done, with everything from the legal whistleblower debate, why not redefine a lot of these terms based on modern living? Why not amend this? Why not rewrite it? I mean, Britain has an Official Secrets Act that's pretty damn specific. We had conversations about creating one of our own, but it seems 100 years is long enough for a particular bill to be around before we make it apply a whole lot more to today.
Well,
I'll go. I'll let you
yeah,
go.
no, I mean, I think I know what Mark is going to say here, so I don't want to steal his thunder. I mean, in the abstract, I think that's an excellent idea. I think that the law is in egregious need of modification because, our understanding of the world of espionage and of national security and also our political culture have changed radically in 100 years. I'm worried about the dangers of opening this whole thing up, though. I mean, if we could just go, immediately from where we are now to the, to a law as Mark Zaid might write it, and we just take that, I'd be cool with that. But the political process in between is what scares the bejesus out of me, and we might end up with something significantly worse. And I think actually, and I'm going to caveat this later, but I think as a first-order approximation, I think an Official Secrets Act, for instance, nice and narrow, and I think really a problem. I don't think an Official Secrets Act, which, as you note, we've come close to having in various times, including in 1934 and I think during the 90s as well.
In 2000.
In 2000.
Except for us wonks and national security wonks.
Nobody really
and
noticed.
The Democrat-controlled Congress and the Congress as a whole passed an Official Secrets Act as part of the Intelligence Authorization Bill that President Clinton vetoed because of that provision.
And I think it
This was
probably
Dianne
its answer.
Feinstein was, I think, the chair of the Senate Intelligence Committee at the time, if I remember correctly. And we came that close. I don't remember what leaks spurred it on, but we came that close. And that was a Congress, at least the Senate part, because the House obviously was impeaching President Clinton at the time. But that was a Senate that we would look back on now as being tame. 2000 doesn't seem that long ago, but it's almost a generation ago. There is no way in hell I want this current Congress getting a hold of the Espionage Act and trying to bring it into modern times. The Patriot Act, for most of its purposes, all it was doing was updating existing statutes to bring it into technological advancements. And look at all the stuff that happened as a result. There were obviously some new provisions that were put in, and the ones that have been most controversial. But if you amend it, then that opens the door to all sorts of other litigation to challenge the constitutionality of it. The statute, frankly, has rarely, maybe is a subjective term, is uncommonly used. I mean, even with the 9 leak prosecutions in the Obama administration, and there have been lots more, because I've handled others that nobody knows about because they weren't leak or whistleblower cases, they were just mishandling classified information. The former government employee was found to have stored classified information at their house, and for whatever reason, DOJ decided to prosecute them. That happens not that often, but it usually becomes a clearance case or a personnel case if they're still employed. So, we tracked over like 100 I'm trying to think, it was including, no, obviously wasn't including, over 100 cases in sort of the last 60 years, after World War I, of Espionage Act prosecutions, most of which are not leak cases, and most of them are spy cases or mishandling cases. So we haven't seen that many. Now, we could attack which ones have happened and whether they were abusive, especially in sentencing. I think that's more the case than the case itself. But I'm concerned if they changed it and tried to update it, it would just make a mess. If you tried to add in some sort of journalistic provision, it would be politically a mess. If they got it wrong, and then it opened up doors for challenge, and you don't know. So again, let's look at Snowden's issues, the information, not himself. The Second Circuit decided that the NSA had exceeded statutory mandate. So if they amend the Espionage Act, who's to say the government's not going to take it a step further because of the way they interpret it? Let's talk about, it's not with this, the torture memos, right? John Yoo and I'm blanking on the other guy.
Steve Bradbury.
Thank you. Who was just nominated to be the Department of Transportation's general counsel, correct, I believe. Right? This was these are smart guys, and they interpreted what is torture in a vastly different way than most of us who have dealt with war crimes issues, including the Army, which said waterboarding is torture, because we prosecuted Japanese after World War II for waterboarding our troops that they had captured. So lawyers, we can manipulate all sorts of stuff and come up with all sorts of definitions. I would rather have the statute, as bad as it is and as broad as it is, stay the way it is and let the government make policy decisions that hopefully we can change or influence as to when they do something that takes a little bit step forward and we go, stop it, go back.
Well, it'd be annoying to have to learn a whole new law too. You'd no longer be the expert. Everyone would be in the same boat.
I don't know. Everybody on Twitter apparently says they're the expert on.
So let's talk about Twitter. No, let's actually talk about from today. Let's look at.
If you saw my arguments on Saturday with John Cusack for 4 frickin' hours.
Yeah, I appreciate you. I appreciate you pulling. I appreciate you pulling me into that. Thanks a lot. So let's look at what is going on right now, and we're going to open it up for questions in a moment. This is really kind of the final one to lead into what I assume will be certain questions focusing on this. And this is for Stout also, because you know enough about the universe. It's certainly the espionage side. This is not about leaking and whistleblowing. This is about straight up spying in many cases. From what we know, or what we think we know based on open information, has anything risen to even remotely near the level where we can have a conversation about the Espionage Act today.
What do you? I'm not sure.
For stuff that's happening
Carter
now.
Page, Paul
Oh.
Manafort, Mike Flynn Sr. I'm not going to even go higher. Let's keep it relatively low. We're an apolitical institution, but there are people that look like they are in trouble. The lawyers have lawyered up, for God's sake. I don't know if you read that article. That was one of the most extraordinary things I've ever seen.
Well, my answer to that would be no, but I got a really, really bad feeling about this. But I don't think there's anybody out there who, even if one takes facts as reported in the press as being true, I don't think there's anybody in my mind who yet would qualify as a spy. But I'm really concerned about what we're going to find out.
Well, I would say yes, because I'm going to answer a different question than what Mark.
The lawyer.
I'm just going to take it a little bit broader.
I don't know why I'm even sitting here. If you're going to answer whatever the hell questions you feel like.
So I would say some of the leaks surrounding everything that we know about President Trump and General Michael Flynn, some of those have been in violation of the Espionage Act. The information with respect to any surveillance communications between Michael Flynn and Ambassador Kislyak of the Russian government, that was clearly illegal.
It's
a
most
leak,
likely
but not necessarily.
Yes, yeah, I agree with that. The leaks probably released.
But
some
what
of
the
them
question
probably
you were
are,
answering, I would
was
agree.
Administration officials or campaign officials. That's what I was getting at.
Now, I mean, there might be some other violations of the Foreign Agents
Agent
Registration
Registration
Act and I'm blanking on the other act that people keep throwing out from 200 years ago that no one's ever
The
been.
annulments?
Logan Act.
Logan
I
Act.
mean, I don't see that
That's not going
happening.
to
I mean, the government doesn't want a test case either. I should say the one case where it came close to where that gave actually protection, so to speak, to the press, which we didn't talk about, was the AIPAC case, the American Israeli
Political action.
Public Affairs Committee.
Yeah,
Right? I got it right? Weissman and Rosen, who were prosecuted under the Bush administration for having received classified information from Lawrence Franklin, who was a DIA analyst or DIA employee, I forget what his position was. He was prosecuted for leaking, because he signed an obligation, a secrecy agreement. What was unique about the Rosen-Weissman AIPAC case was they had never signed. Well, I don't think they would ever. One of them at least had never signed. I can't remember if both of them.
Neither of them had clearance at the time.
They certainly didn't have clearances at
Yeah.
the time, and they didn't have authorized access. And what they were doing was funneling information from Franklin to the Israelis and journalists. And they were prosecuted because they pissed everybody off in the Bush administration, apparently. And the issue was, well, could you prosecute them? And their case went on for years, and frankly, really destroyed their careers and lots of indebtedness, obviously. And believe me, it's not fun, certainly, being prosecuted at all, or even sued, if you've ever been sued. It's fun suing people.
And representing people who are being sued.
No, that's just financially
Right, yeah. That's what I was getting at.
But fortunately, the Eastern District of Virginia, which hears most of these cases, raised the bar, created a bar, because it's not in the statute, that basically said Rosen and Weissman the government would have to prove that they had intent, that they were trying to harm the United States. And oftentimes when Franklin sent them information, they didn't even know it was classified, because he would cut the headers off or rewrite it. I don't remember the specifics, so don't quote me on it. But they'd get a fax, and they wouldn't know if it was classified or not. So that raised the bar, and then eventually the case. I represented actually Bill Leonard, who was used to be in charge of the Information Security Oversight Office, ISOO, in the National Archives, classification czar, and he was going to be a witness in that case, and I was representing him because they were threatening to prosecute him if he testified for the defense, because he was going to testify that the information wasn't even classified, or it was of the type that everybody was circulating around D.C. But because the judge raised the bar, the case collapsed, government dropped it, so that gives some protection to any one of us who haven't signed a secrecy non-disclosure agreement, because theoretically, if you had a copy of No Easy Day, the government said there was classified information in it, or a better example, go to WikiLeaks, download a document that's still marked secret, and It doesn't matter that it's a copy. You're in violation of the Espionage Act. Now, is the government going after anybody for that? No, of course not. Although they tell people who are inside the government, do not go to WikiLeaks, even at home. And they even, one Air Force, Wright Patterson, some idiot, sent out a memo to everybody on the base saying, if anyone in your family is accessing WikiLeaks, like your grandmother, you need to tell us so that we can do something about it. And when that leaked to the press, that policy was gone.
Of course that leaked as well.
But the short answer, swinging back, what's going on with Russia, it doesn't look to be Espionage Act issues other than the leaks that we are learning about what's going on with respect to Russia.
Right.
You getting the vote?
No. Basically, this was a logistical thing. So we are going to open up the questions. So normally we have a microphone so that the camera can pick it up. So when you do ask your question, try to ask it loudly. That's what Amanda was actually whispering in my ear. If not, I'll repeat it loudly so it can get picked up. Yes, sir.
Okay. Now we have a legitimate need to protect classified information. Let's say a government employee has uncovered evidence that is classified that would prove the treason of high officials either in his or her agency or outside. Which trumps? The need to protect secrecy or the need to prosecute treason and remove treasonous officials from office?
No pun intended.
Yeah.
Right. You said which trumps.
So, I think from a legal perspective, it doesn't matter from the statutory language. I think, and the biggest problem, obviously, the argument is that, well, where am I going to take that information to if everyone up through my chain is complicit or is not going to do anything? And most of the time it's that they won't do anything. I think I coined this, and if not, I'm coining it. The conspiracy of one, which by law you can't have. But anyone who's worked inside the intel community, especially in CIA, DIA, will know what I'm talking about, because anyone who is in trouble for something or perceived to be in trouble, everybody starts moving away from them because nobody wants to get caught up in whatever the hell it is that they're caught up in. And there's this, and the person starts feeling like everybody's against me. It's a conspiracy, but it's really a conspiracy of one because all these people are making individual decisions to just back off. That happens a lot. Look, when I took Jeff Sterling up to the Senate Intelligence Committee, and he blew the whistle on whatever it is he blew the whistle on, because I wasn't, my clearance wasn't at that level, so I couldn't sit in on the meeting. And then I can't even say allegedly anymore, unfortunately, because he was convicted of leaking supposedly the same information to the New York Times. I'll put this hypothetically. Apparently, then he wouldn't have thought that the Senate committee did what he wanted them to do, whatever it was, because nothing happened in 3 years. It didn't show up anywhere in the newspapers or anything like that. So that's a real problem. And then it really comes down to, I think, your individual subjective belief as to what is right and what is wrong. What I argue is I want you to at least try. You have a legal and a moral obligation to do everything you can. We can come up with lots of hypotheticals like yours that are really egregious, and that would change what our decision process would be. Thankfully, I don't know of any cases that have ever been like that bad.
Stay tuned.
We're good. We might see it. I'm not saying there have been numerous cases where there's bad things going on. I would want the person in Abu Ghraib to reveal that information, but that was isolated to the idiots in the West Virginia National Guard who were doing that, and that could have been a case that was brought to the IG office in the Defense Department, and I can't imagine, I can't say guarantee, I can't imagine that they wouldn't have acted on that, because there's no way they would want to any of their people doing that, because that's not what we do, hopefully. So at some point in time, look, you try and you go through the levels, and the levels could differ from case to case, and then so that person's going to have to make a decision as to, are they willing to risk their criminal exposure. I mean, Dan Ellsberg has a very different opinion on things now than he did when he was a young man, when he did everything right back at the time. I mean, first of all, it was all historical information he was releasing. It wasn't impacting current operations, which is why the Nixon administration was a little bit nuts to go crazy on him, because it actually made the Eisenhower and Kennedy administrations look bad. Not necessarily his. He did his own things with carpet bombing, but that wasn't in the Pentagon Papers, because that was Pentagon Papers was a history. He went through his leadership. He wrote a bunch of the Pentagon Papers for Rand, and he went through his leadership, didn't get anywhere. He went to the Hill, he didn't get anywhere, and so then he decided to leak it. And then once the information became public, he stood on the courtroom steps and said, "Here I am, prosecuting it." He owned it.
Yes, ma'am.
I have two questions, hopefully quick questions. I remember with the Iraq War that with the use of contractors like Blackwater and stuff, they ended up sort of in a little bit of a legal no man's land. So my question goes to, with the use of contractors in the intelligence community, are there completely the same regulations, same legal vulnerabilities, everybody signs the same sort of secret document that they're not going to disclose, or are there variations or any potential downsides to the growth of using private contractors like Booz Allen?
Well, there's a ton of downside for that, but
well, legally.
yeah. Well, I mean,
Well,
they're
so
signed
yeah,
the same class.
They're under all the same
Yeah.
obligations and go through the same clearance processes as people who are government officials. As I understand it, the difference is, correct me if I'm wrong here, there's no whistleblower sort of procedures and laws for contractors. Am I right?
There were so the President Obama issued PPD 19, Presidential Policy Directive 19, and there's more protection for contractors. It's always a little
But
bit
it's
dicey.
different from government.
It's always going to be a little bit different because it's not like the government can tell a contractor don't fire that person. I mean, there's ways in which they could punish the contractor if there was retaliation. And there are provisions now if your security clearance is targeted as retaliation. But again, it's not targeted by the contractor per se. It's targeted because only the government issues security clearances. It gets murky.
So is this one area where safe reforms could be made, is in whistleblower procedures and protections for contractors? Without opening up all these cans of worms that
So
we were talking about
there's three, I'll go generically, three primary provisions. There's the Whistleblower Protection Act, which doesn't cover the intel community. It's useless for intel. Then there was the Intelligence Whistleblower Protection Act in 1998, which doesn't protect anything. All it does is a great name. Doesn't protect anything. All it does is set up a procedure for people to blow the whistle predominantly either through inspector generals or to the Hill, but it doesn't really give any protections. And then the Obama administration issued actually some teeth. I mean, but it's so new that we're in the earliest stages of seeing how effectively, if at all, that they work. So there's no doubt that if I'm going to reform anything, it's not the Espionage Act. It's going to be strengthen the whistleblower protection laws to enable people to feel comfortable to come forward. Manning is the sorriest of the examples. I always say he because at the time when that happened, he was. I don't want to get caught up in the he, she. So I'll just say Manning. When Manning leaked the information or held concerns at the time, such as the Apache helicopter video, which everybody might have seen, which is horrible to watch. And there's these pilots gunning down with like 50 caliber or something.
It's actually
really
25 Mike. It's much bigger than that.
really big bullets.
Yeah.
And they killed a Reuters journalist. They didn't know it was a Reuters journalist. What's so callous about it is the callousness of it, because war has made it into a video game. So you can legally, whether you like it or not, by the legal conventions internationally, you can kill rescuers. Bad guy rescue. Bad guy going to rescue the other bad guy is still a target. And that's what they thought this person was, without knowing it turned out to be a Reuters journalist.
I mean, that's why half of Arlington is filled up with medics and corpsmen. Under the rule of law, you can kill those.
So, if Manning had gone, Manning as 19-year-old private, the Army system is not designed for a 19-year-old private to complain to the 20-year-old corporal about what's in these videos. It just doesn't exist that way. And what I always tell the government is, I wish anyone who's been in the government, you take your annual EEO refresher course that you probably just push the button on the computer. Yep, read it to get through it. Why don't we do that for whistleblower protection? Why isn't there guidance given out to everyone who joins the federal government or as a contractor who has access to classified information that says, if you see anything that is waste, fraud, abuse, gross mismanagement, or especially unlawful conduct, here's what you should do. And we will protect you if you do it.
Well, it seems like the common sense solution to
But
the
they don't do
question is putting the contractors under the agency that they're being contracted from. Meaning,
The
if
rules apply to the
you're an NSA contractor like Edward Snowden was, then you would be under the, even though you work for Booz Allen, you would be under the auspices of the NSA whistleblower hierarchy going up to the top.
They could do it. And there are some, for those who are contractors and you deal with your facility security officers, your FSOs, there are these hybrid. The person's an employee of the contractor, but they're actually operating as an agent of the U.S. government because they're dealing with U.S. government information and processing clearances.
Let me go behind you. I know you have a second question. Yes, sir.
You were talking about the legality issues regarding a lot of the recent leaks related to whatever investigation is happening with Flynn, Manafort. When do those leaks start being detrimental to the overall investigation that Mueller, that the FBI, and Congress even is running?
That's a great question. I mean, that's as much a policy
Probably
question.
already.
Yeah, I'm sure already.
But what kind of legal impact can that have on the event?
Oh, it's for letting people get off down the road, basically.
Yeah.
I mean, is it?
Like,
Are there
I wasn't
evidentiary
able to have a
issues?
fair,
Right.
a fair defense because all of this had been out already before it reached that stage of the prosecution.
Well, I mean, they managed to find juries to convict all sorts of infamous, murderers and whatnot. I mean, Charles Manson got a fair jury ultimately, for instance. So
There are a lot of people out there that have no idea what's going on.
Yeah.
We're in the Washington bubble here. We're paying attention to every word that comes out. My family that lives in Florida and Texas are like, oh, there's controversy happening right now. It's like, just keep watching sports, Dad.
This is Washington elitism right here,
right
now.
Yeah. So I mean, there is a question about whether or not the actual prosecution can use things for the evidentiary chain of evidence kind of things. If stuff comes out just through a leak, maybe there's an issue there. But I'm not sure we've ever seen that.
So there's I'm sorry. Go ahead.
No, not as much from a prosecution standpoint.
There's a couple of issues there. So if what's being leaked is something that's obtained, pursuant to a legal proceeding, a wiretap with a warrant and all that, that's one thing, and maybe there could be issues of chain of custody. I don't know. I'm not. But if it's something obtained in general, and there's exceptions to this, but in general through intelligence processes, broadly speaking, those sorts of things aren't admissible. In court, and again, there are exceptions. But if for instance, CIA goes and recruits somebody in the Russian GRU and they hand over documents, those documents could be incredibly valuable for intelligence analysis, but they are legally speaking utterly useless because
you would use them anyway. Because
even if you did,
forget admissibility because
sure.
This goes
even
back.
If you did, and there's a similar thing with most, not all, but most signals intercepts, right? That. What is this? Where did this come from? Show us how you got this. Show us why you have reason to believe this is what it purports to be, as opposed to.
The sources. So, I mean, they're
the intelligence world and the legal world overlap, but they really don't mesh very well.
There were generations. The most infamous he is now, atomic spy, was Ted Hall, who was this 19-year-old kid who was part of the Manhattan Project and gave more to the Soviets than anybody did. Of course, Julius and Ethel Rosenberg get fried for passing along nonsense, essentially, to the Soviets. Ted Hall was way more important, but the only evidence we had against Ted Hall was from Venona, which was a signals intercept program that was still very classified, and we weren't going to break classification in order to prosecute this kid. So Hall never got prosecuted.
Yeah, so right, exactly.
He lived the rest of his merry life knowing that he had essentially given the Soviets the bomb as much as you could give the Soviets the bomb, and was never spent a day in court, let alone prison, for doing it.
Yeah, that's a very good point. You have to get over all those concerns before anything I said comes into play. So this is really just typically not.
Yeah, so the NSA doesn't give a rat's patootie about prosecuting Carter Page, right? Especially if it means outing, their ability to read Russian messages or other things. And I think that's some of the real difficulty here is some of these reports that are coming out like, there's only one way they could have found that out, and that's if we're listening to high-level conversations taking place.
And that's
in
the
Moscow.
real problem. I've never worked for the federal government. I've only sued the federal government. I can tell you that the CIA does not like me. I was told that today by another government investigator, actually, who talked to the CIA, and he's like, by the way, they don't like you there. I'm like, okay. But I've seen enough, even from my own clients, where they think something bad has happened, and they only see a piece of the puzzle, and they don't know the rest of it. And that's the biggest problem with leaking classified information, because most people only have a very small compartmented look at things unless you're really, really high up. And the ones we've seen recently are all millennials, and we could have a real interesting conversation. But that was saying to leak. They wanted more millennials to leak information. Now, the only thing about that I think is different on the millennial leaking standpoint is just that when we grew up at that age, I mean, when you're ideologically,
when you two grew up,
you're a little young. We didn't have all the computers and the internet, and that has changed some of the things. I believe some of the outlook. The difference is how we look at privacy. But knowing that there were conversations between Flynn and Kislyak, that's as sensitive as you can get. But I don't think we told the Russians anything, because I presume Kislyak assumes all of his conversations are being monitored. He'd be an idiot on the phone if he wasn't assuming that. But let's look at the document that allegedly Reality Winner leaked, which had to do with Russian infiltration or attempts to infiltrate in the voting machines. Now, for one thing, everybody was talking about that months ago, because everybody was thinking about ways, what could the Russians have done? We didn't know the specific companies. So this memo outlines identifying specific phishing attempts that the Russians sent into the system to these companies. And it gives a timeline, a chronology. Now, that chronology may vary. This is my own experiences, I'm just saying. That chronology may have given the Russians some really significant intelligence insight as to how fast it took the U.S. government to figure out what the Russians were doing. And nobody's paying attention to that. When people are looking at it from an ideological standpoint of, because I was getting into this debate with people, of course she's a whistleblower because we should know that the Russians were trying to hack into our voting machines. Not necessarily. Let the intelligence community do its job and investigate it. Yeah. We don't necessarily need to know what the U.S. intelligence community is doing at this time, because if by doing that we may be harming being able to stop them from doing it the next
There's
time.
a bottom line to all this, and that Bob Mueller wants everyone to shut up.
Yes.
I think that if you want, one way or another, if you want this investigation to come to a conclusion at some point, any leaks are problematic now. And that's why you've seen people clamming up. People who are very talkative and are anti-Trumpers or whatever you want to call them, people who are very outspoken have now stopped talking. And you can see when Jim Comey did his testimony, he went to Mueller first and said, is it okay to even make any kind of these conversations public? Because he wants this investigation. Anyone would want an investigation to be tightly controlled. And so leaking doesn't help either side at this point. But keep doing it because I love it. No, yes, sir.
So you started with World War I, into the interwar period, went to World War II, kind of glossed over the 60s, maybe I just hear it. Then we picked up with 1971 and beyond. So I have to assume that something happened in the 60s, Cold War, Vietnam, something with the Espionage Act, nothing?
Real spy prosecutions.
Yeah.
Mostly.
Yeah, I mean, I'm sorry. I was just going to say the sort of after World War II and before you get to Ellsberg, I mean, the big development was the amendments to the Espionage Act in 1950, which broadened out from the Yardley legislation to basically anything to do with cryptology. Basically, is a no-go. And
then in 1953, you get the only two people ever executed under the Espionage Act, which we've already talked about. The
Interestingly enough, and I had never really thought about this until I was reading something just the other day. Interestingly enough, I mean, when the Rosenbergs gave, or at least when Julius gave whatever he gave to the Soviets actually were our allies at the time. They weren't actually,
Well, that didn't work for anybody.
That didn't work for Pollard.
Well, exactly.
And
that actually was one of the turning points in these cases from the 1930s. Is that wasn't clear legally speaking until 1938, when another case involving actually espionage for the Soviets, with whom we were not at war at the time, and that was actually a legal issue that got decided that no, actually, it really doesn't matter whether we're at war.
We've never been at war with the Soviets, except for when we fought with the White Army in in Siberia by accident,
right.
during the revolution. But
yeah.
I mean, the Rosenberg Julius at least did leak stuff into 46 and 47. A little bit post World War II. But no, I mean, you don't have to actively be at war with somebody, obviously, for this to take place. So we're running up against it. Let me take one last question, and maybe they'll be nice enough that I'm going to stick around for some shorter ones after. So who wants to end us off? Yeah, I saw. Yes, sir.
This is reaching back even further than where we were. The gentleman took us a
Do it.
second ago.
We like
Early
history.
on,
Mark does.
its first incarnation of the act was challenged all the way up to the Supreme Court and upheld.
Yep.
Skank, I think, was the case.
Yeah.
Two-part question. What was the legal reasoning there? Does it still obtain in your view? And has the paucity of Espionage Act prosecutions meant there have been no more Supreme Court cases, or is there other reason?
I know the case you're talking about, but I haven't gone back and
If you don't,
That was
and
it
read
had
it.
enunciated a clear and present danger standard for communicating information.
Yeah, I mean it was tied from the wartime perspective, so everything is thrown off.
So so there was a case.
I don't remember
There was a
this.
case in '41, so involving the Soviet thing I was just mentioning in a slightly different context, that upheld it as well, and actually where the court says the country
SCOTUS
that SCOTUS case, the country that you leak to is completely irrelevant, and by the way, it doesn't even have to be a government you leak it to, and it applies there.
But I mean, during wartime, these are the Supreme Court's making extraordinary decisions during wartime.
This was before we were at war.
41 is before we were at war. I mean, we're on a war footing at that point.
It had been in the court since '38.
So you're about to see a nerd fight going on here again. I mean,
yeah.
When you have things like the Patriot Act and Korematsu and others that are wartime decisions, you almost have to throw those out the window. I mean, I think that
but it still stands. Yeah.
Yeah, well, it hasn't been unless it's been specifically
challenged,
which it
Yeah,
hasn't been.
not.
I don't think they've
That's the
just
Goran
gone
case.
into it. They've gone down different paths. The one thing I want to say, actually, we're talking about amending again. The one point I always also like to make, if I amended something, actually, I wouldn't touch it. I would just split it, because I split into two, because you hear a lot about the leak prosecutions of people complaining that it's an espionage case and that they didn't commit espionage, and it's absolutely true. It's a classified leak provision or that's being subject to. So if I did anything, I would split it into espionage. So this is Spies to Classified Leak Prosecution Act, so that it's clear.
But then you have to.
I'm not saying this is not realistic.
Yeah,
I wouldn't tell them to do it.
Intent, right? Like, so Snowden is a leaker, so he should be tried on the leaker side. Except half of the country thinks Snowden is working for the Russians the whole time.
Yeah, but the U.S. government is not right now about to prosecute him under the 794 provisions that deal with what Aldrich Ames was under, or 798.
Right, because it's a lot easier to prosecute him on the other side.
But, I mean, if they have the evidence.
Right. No.
But again, if they have the evidence, maybe they don't want to use it because it would reveal some source we have in Russia. I mean, that was the Kim case that was so disturbing about it from the U.S. government standpoint. It was about North Korea, and this is where the harm could come from, and it doesn't even have to be realistic harm, or not realistic reality. So real quick, Kim gave information. He pled guilty, so I can say he gave information to James Rosen of Fox about what was going on at the UN Security Council through the State Department about how would North Korea react to the Security Council doing this or that about another North Korea nuclear test. And the article got written, and only about 50 or 60 people had access to that information, so technologically wasn't difficult to zero in on him, especially when he talked to Rosen on his State Department phone. And while he was accessing the document that he was prosecuted for, there's 2 strikes, and they both left the building at the same time, because there's a machine that you scan in.
Walking arm in arm.
But the thing that was so disturbing about it was the way the article got written, and I have no idea if this is what the document said or even what Kim said. the way the article was written, it made it appear that we had a source in North Korea. And I don't remember if it was clear if it was a human source, a human intelligence source, or a SIGINT source, but it made it clear there was a source. And that might not have been true. Maybe Rosen got that wrong. I don't know. But if you think about how, tyrannical and mental the North Korean regime is,
There are dead people.
You better bet there are dead people in North Korea as they went to search for any possibility of who could have been either responsible for the source or maybe was responsible for the leak that went through signals and who knows? And I'm
We
just
could
saying,
have just leaked that there was a source so that Kim Jong Un would just kill a bunch of people.
yeah.
That's all. I'm just.
There was
I needed to
precedent
cut
for
off
that.
the conversation. Yeah, there
So
is
at least
precedent. for that.
that's the type of concerns that come out of these type of leak cases that I don't think people think about as to what the ramifications might be. I always hear all the time within the Snowden camp, well, can you show me that anyone was killed as a result of Snowden's leaks? I mean, I can't. I don't know. And my response would be, okay, if I showed you that one person was killed, is that enough for you? Or, all right, how about 3 years from now, 7 people die, but nobody died in that first 3 years? Is that okay? So, where do you go from it?
Can I make a very fast announcement? I'm sorry. The National Whistleblowers Center that Mark knows well. National Whistleblowers Day is on July 30th. It codifies the first whistleblower case, as you know, was during the Revolutionary War. But my point is just that if you're in town on July 27th, Congress, the Senate is having a panel to discuss the senators and congressmen, and some of the biggest people who are involved in whistleblower cases will be there. So if you're interested in that, it's free. It's in the Kennedy Caucus Room, SR 325. So just a thought. Thanks. Sorry.
No, absolutely. Thank you. And
Do you want to say anything?
You can. I'm just here.
All right.
so let me wrap up the time, and then people are welcome to stay and have a conversation. So, ladies and gentlemen, let me thank you for being here. Please join me in thanking Mark Stout and Mark Zaid for taking the time here.